Hi, my name is Lindsay Longo, and this is my case law presentation on Hendrick Hudson Board of Education versus Rowley from 1982. I'm going to start with a little bit of case background. This is a case about a first grader named Amy Rowley who lived in New York, and she was born to two deaf parents. She herself was deaf and labeled as having a hearing impairment. She completed a successful kindergarten year in 1977. She used a classroom hearing aid, and the school administrators used sign language and a teletype machine to help support her in her education. At the beginning of her first grade year in 1978, the school and Amy's parents went to revise Amy's IEP accommodations. The school suggested that she continue the use of the hearing aid, having 1 day a week with a special tutor and having 3 hours a week with a speech therapist. Her parents disagreed with these accommodations. They wanted Amy to have a full-time qualified sign language interpreter in lieu of these other services. To help with the disagreement, an independent examiner was brought in to take a look at the situation. He also found that a sign language interpreter was not necessary because Amy was achieving on grade level without the use of this particular accommodation. She was achieving on grade level with the special education services that she was receiving already. Again, the Rowleys, still disagreeing, filed a civil suit in the U.S. District Court in New York, and they argued that she was not receiving a free and appropriate education that was defined by law. This brings us to our constitutional question. What does it mean to have a free and appropriate education? And this was the first case to really question this law, and it was because the law did not provide a clear definition of what free and appropriate should mean. And the law back in 1982, when this case was finally decided, they were still working under the Education of All Handicapped Children Act of 1975. Now revisions of this law is now known as IDEA. So the case started in U.S. District Court in New York, and the court found that Amy was a well-adjusted little girl. She advanced easily from grade to grade, but since she understood and comprehended less than if she weren't deaf, they found that she wasn't performing as well as she could. And due to this difference, this discrepancy between the level she was able to achieve and her potential, it was ruled that she wasn't receiving a free and appropriate education as defined by the law. The school district appealed this decision, so it moved up to the next level of court. So it moves up to the U.S. Court. The case moves up to the U.S. Court of Appeals, and the U.S. Court of Appeals affirms the decision made by district court. They said since there was a discrepancy between Amy's achievement and her potential, that she wasn't receiving a free and appropriate education. The case gets appealed again and finally goes to the U.S. Supreme Court in 1982. And now this is important. The U.S. Supreme Court reverses the decisions made in the lower courts. They ruled that Amy was receiving a free and appropriate education without the use of a sign language interpreter. And this was a 6-3 ruling, with 6 justices agreeing that she was getting an appropriate education and 3 dissenting saying that she was not. So the opinion of the court, or the majority opinion of the court, can be summed up by this quote. I'm just going to read it. It says, "Thus, if personalized instruction is being provided with sufficient supportive services to permit the child to benefit from instruction, and the other items on the definitional checklist are satisfied, the child is receiving a free and appropriate education as defined by the Act." What that means is that if a child is receiving personal personal instruction, if they are receiving their IEP services, if they're receiving their special education, and they are benefiting from those services, then they are getting a free and appropriate education. There's no qualification in the law that says a child has to reach their potential. It just says a child has to benefit from the services. And it wasn't the purpose of this case to define exactly what that word benefit means. So they left that for later court cases. So the U.S. Supreme Court focused their decision-making on congressional intent, or what Congress had intended when they passed the law. And the real intent of the Education of Handicapped Children Act in 1975 was just to bring previously excluded students with disabilities into public education. At that time, so many students who were needing special services weren't even allowed in the public schools. So the purpose of this law was to open the door to public education for all of these students, but it was not to promise any particular outcome in their education. It was just to allow them to have an education. Justice Blackmun wrote a concurring opinion and agreed with the court's decision, but he read it as they focused too much on Amy's achievement versus her equal educational opportunities. But he did find, since she was receiving equal access to the material, that she was receiving a free and appropriate education. Justice White led the dissenting opinion, and he thought that she wasn't receiving a free and appropriate education because she only comprehended half of what her peers could comprehend, regardless of if she was achieving on grade level or not. And he thought it was up to the courts to define what this meant. So here are my references. Thank you for listening. Above all, this was a really landmark case because it was the first to define what a free and appropriate education meant, and they found that as long as the student is benefiting from personalized instruction, that they are receiving a free and appropriate education. Thank you.